We have finished question answer on property law or law of property as per the provisions of Transfer of Property Act up to question answer 38. So today we will discuss question number 39, which asks elucidate the doctrine of consolidation of mortgage. Is a mortgagor bound to redeem two or more mortgages in favor of the same mortgagee together? So, the very answer to this question we found as in the decision of Jennings versus Jordan, and where Lord Selborne explains, and as per the provisions of section 61 of the Transfer of Property Act. So it is the equitable right of the mortgagee who holds more than one mortgage granted by the same mortgagor on different properties to insist after the time of redemption has expired that the mortgagor shall not be allowed to redeem one without redeeming the others as well. This right was based on the maxim that he who seeks equity must do equity. This equity has now been abolished in England. In India, Section 61 abolished the doctrine of consolidation of mortgage. Under Section 61, a mortgagor who has executed two or more mortgages in favor of the same mortgagee shall, in the absence of a contract to the contrary, when the principal money of any two or more of the mortgages has become due, is settled to redeem any one such mortgage separately or any two or more of such mortgages together. So, we will discuss one illustration regarding consolidation of mortgage. As for example, A, the owner of farms X and Y mortgages X farm to B for Rs 1000. A afterwards mortgage the Y farm to B for Rs 5000. A may institute a suit for redemption of X or for the redemption of both X and Y. And the second illustration, that is relating to consolidation of mortgage, is A mortgage X farm to B. Later on, A mortgage X farm again to B by a subsequent mortgage. A may either redeem the latter mortgage or prior one or both simultaneously. So the very doctrine of consolidation was explained by Lord Selborne in this leading case, Jennings versus Jordan, where he observed that a mortgagee who holds several distinct mortgages under the same mortgagor, redeemable not by express contract but only by virtue of the right which in English jurisprudence is called equity of redemption, may within certain limits and again certain persons entitled to redeem all or some of them, consolidated them, and that is, treat them as one, and decline to be redeemed as to any unless is redeemed as to all. The doctrine of consolidation, as explained above by Lord Shelburne in Jennings versus Jordan, applied in India before the commencement of the Transfer of Property Act 1882. The doctrine rested on the principle enunciated in the maxim, he who seeks equity must do equity. And now we'll go to question number 40, which asks, state the law of accession to mortgage property. Discuss the respective rights of the mortgager and the mortgagee as regards to such accession. So the very answer that we found under section 63 and also under section 70. So the mortgager's right as we found under section 63 are three different rights. One is natural accession, the second one acquired accession, which are separable, and also to explain the second one we have to discuss one illustration, and the third one, that is inseparable accession, and regarding that also we'll discuss an illustration. Then we'll go to section 70 where we found mortgagees right as regards to accession. So, accession to mortgage property, the very term accession primarily denotes physical assertion or addition. The rule is that increase follows the principle. Accordingly, any addition or increase become part of the mortgage property. Section 63 refers to the mortgage's rights to accession, while Section 70 refers to the mortgage's right to accession. So, Section 63 deals with natural accession acquired by mortgagee, accessions which are separable, and the third one acquired by the mortgagee, accessions which are inseparable. So we'll discuss the first one, natural accession. There are additions to the mortgage property by natural causes. The general rule is that such accession to the mortgaged property are subject to redemption. For example, a mortgage to be a certain field bordering on a river. The field is increased by alluvion. A is entitled to this increase on redemption. And the second one right is acquired accession which are separable. So these are accessions made by the mortgagee in possession, but they are capable of severance from the property if the mortgagor wishes to take them. He must pay the expenses of acquiring them. And in connection to that, we'll discuss the illustration relating to this particular right. A mortgagee created a stable on the mortgage land and the materials of the stable could be removed without injury to the property. It was held that it was an accession which could be separated and the mortgagee had the right to remove the material. And now we'll go to the third right, that is inseparable accession. When the accession made by the mortgagee are inseparable, the mortgagor has no option but to take them on redemption. He is liable to pay cost only. If the accession was necessary to preserve the property from destruction, forfeiture, or sale, and secondly, if accession was made with the mortgager's consent, and in relation to that, we will discuss one illustration, and that is A brought a suit for redemption against B, the mortgagee. The mortgagee claimed the expenses of constructing a well in place of an old one which had been destroyed. The mortgage property was an agricultural land, and as the existence of a well was necessary for the purpose of preserving the agricultural character of the land, the mortgagee was entitled to expenses. And now we'll discuss section 70, which deals with mortgages right as regards to accession. So, under section 70, the mortgagee is entitled to treat natural accession and accurate accession as part of his security. Thus, if the mortgagor builds on the property mortgaged, the building forms part of the mortgaged property, and in the event of default in payment, the mortgaged property along with the building is liable to be sold. So, this is the correct and exact answer to question number 40, which state the law of accession to mortgage property, discuss the respective rights of the mortgagor and the mortgagee as regard to such accession, as we found the very provision relating to mortgagor's right in relation to accession as provided under Section 63, so also mortgagees right as regards to accession as provided under Section 70 of the Transfer of Property Act. So, this should be the correct and appropriate answer to question number 40. And before that, we have already discussed question number 39 that elucidated the doctrine of consolidation of mortgage. Is a mortgager bound to redeem two or more mortgages in favor of the same mortgagee together? So the very answer, even if it is not clearly found under Section 61 of the Transfer of Property Act, but the very decision and pronouncement of Lord Selborne in the leading case Jennings versus Jordan clarified exactly what means consolidation of mortgages, and in relation to that we also discuss the very provisions of section 61 which relating to a mortgager's right or to redeem, and also the very illustration to clarify exactly what the doctrine of consolidation means, and as it is relating to the very maxim that the right is based on the maxim that he who seeks equity must do equity. So, in our next upcoming video, we'll discuss question number 42 and question number 43.